Welcome, everyone. I'm Diane Rodriguez. I'm the new director here at the Law Library since May 1st. So welcome to all of you. Thank you, Mark. The San Francisco Law Library is open to everyone. We have free books, databases, and professional law librarians to help you with any and all of your legal research needs. And we invite you to stick around and explore the law library after the program if you have time. A few housekeeping reminders before we get started. Today's program is being recorded and transcribed, and it will be available on our YouTube channel soon. If you'd like to get MCLE credit for today's program, if you haven't already, please sign in at the table in front, and there's materials, and we ask you to please fill out your evaluation when you're finished and leave it with us at the desk. We get to our speaker today. We are honored and thrilled to introduce today's speaker, Mr. James Brosnahan. He's here today to speak about consequential cases decided by the Supreme Court in the last year and important cases still to come. Mr. Brosnahan is a world-renowned defense lawyer, federal prosecutor, author, and advocate. He has tried 150 jury trials and is a member of the California Trial Lawyers Hall of Fame. Here at the Law Library, we deeply appreciate you and your great support for the Law Library over the years. He's been a true friend to the Law Library. He's also a champion of access to justice, and we thank him for sharing the importance of the rule of law with all of us. If you follow him on LinkedIn, I highly recommend it. It's a fascinating daily update on where you are and what you're thinking. And also, we do have a copy of his latest book, Justice at Trial, Courtroom Battles and Groundbreaking Cases, in our collection for your review, if you'd like to check it out. And with that, please welcome Mr. James Brosnahan.
Very much. We're going to discuss the cases in the U.S. Supreme Court in the last year. And it's a strange time in a lot of ways, and I think it'll get stranger between now and July 1. Let's just remember who's on the court, not that we could forget. Ken G. Brown Jackson, brand new, liberal, will be found in concurring opinions and dissenting opinions very often. Amy Coney Barrett, somewhat new, sort of feeling her way on certain things, but will be a key vote in favor of a combination of religion and law, despite my first controversial statement, despite what it says in the First Amendment, that it has to be separate. And I could be wrong about that. We'll get to a specific case where that's involved. Brett Kavanaugh is a nice man. He was very social in college, evidently went to a lot of parties, and really loves the role. You know, it's a great job. He's not very heavy for this job, and he writes little things. He wrote a concurring opinion about how hard it is on police officers, which is true. That's true, but we all know that. Neil Gorsuch, who believes he's the smartest one on the court, and he might be. It's possible. Elena Kagan, that's the big news. Shifting over to the right. Shifting to the right in enough cases to make it legitimate to point that out. Sonia Sotomayor, tough upbringing, and that formed her personal views that the people are important, a view that's not shared by everybody on this court. Samuel Alito, wake me up when it's time to convict. Chief Justice John, I'll get serious in a minute, but you know, when you flash these names in front of me, I just go crazy. You know? Chief Justice John G. Roberts, nice looking man. Looks like a Chief Justice, disappointing. Disappointing. Doesn't control the court, and very often is kind of pushed aside here or there. And Clarence Thomas, who would take us back to the good old days when women were just in the kitchen. You all remember those days. That's all you could do. And so that's what we're facing. The worst case, and one of the worst cases they ever decided was last July. And the commentators seem to think that giving immunity to the president happened because Trump was elected. It didn't. It happened before Trump was elected. It happened on July 1st of last year. How long had it been the rule of law that no one is above the law? It goes back to the early kings, talking pretty much 1,000 years ago, when there was a right to jury trial in England. And when others stood up to the king and said that no one is above the law. Justice Coke did that. He was kneeling at the time. The king had called 12 judges together and said, why are you suggesting that I can't decide cases? I'm the king. I have prerogatives. And my version of it was that Lord Coke, who was the chief, while he's kneeling, looks up at the king and says, no one is above the law. The case in the Supreme Court decided July 1 changed all that, and they gave two types of immunity. They gave absolute immunity for certain official acts, and they gave presumptive immunity in criminal cases. They authorized the president to commit crimes. It's very simple. You don't need a lecturer to explain the pros and cons. And I think that when President Trump got there, he had a green light that we're all watching on a day-to-day basis. I thought I'd start with the Alien Enemies Act. I know all of you know about this, the Alien Enemies Act. If you are about 150 years old, you will remember that we were at war. You know, enemies were everywhere, and they passed this act. They haven't used it since. But the picture of the president sitting at his desk, signing a piece of paper without consultation with Congress, without a congressional hearing, that had the effect of passing, quote unquote, the Alien Enemies Act. And there are two cases here the Supreme Court took up. They didn't decide whether we're under this act or not. That brings us to a theme of this year's analysis. They are swamped with work. And who swamped them? The President of the United States. And it's working. You'll see here cases where they don't decide things that obviously need to be decided. Why did they not decide the Alien Enemy Act since the administration is using it on a daily basis? I don't know. Really don't know. But I know that they avoided it and sent it back. In both of these cases, Donald Trump, President of the United States, versus J.G. et al., and also the AARP, Donald Trump, President, and they sent it back to the lower courts. But that brings us to something that is not easy to understand. I'm going to do my best to boil it down and give you, because it's, I dare say, the most important procedural step that this court has undertaken in a long time. When President Trump was in his first term. He did something that the district court said he shouldn't do and issued an injunction. I make a general statement. Conservatives are almost always against injunctions because something is happening and it interferes with government wrongdoing. I know that's a hard statement, but it's true. What happened here is that the district court enjoined conduct. The Supreme Court took the case, very, very unusual. They took the case and they stayed the injunction. That means they allowed the executive to go forward without ever examining the merits of the case. Ever examining the merits of the case. And having violated a number of principles in injunctions, they then repeated that so that this morning in the New York Times, they have issued 19 emergency applications. And what is this about? It allows the president to go forward, in the words of Sotomayor in dissent, without an argument on the merits, without hearings, without time to reflect on them. They are doing the president a great favor. Where does this idea come from? It comes from the Federalist Society. They have been thinking for so many years, lusting, you might say, for a president that will be in command of everything. Is that a good idea? No, it's a terrible idea. But it's strongly held by that organization. Several of the justices were regular attendees at those groups. I never saw them at an ACLU meeting. And so that's just the reality of it. But it's been done time and time again, and I'll give you some examples of cases. Here's Justice Roberts on his own, confronted with this case, stayed the district court. What we're hearing on the radio and television is the district courts are saying no, they're saying no, they're saying no, as they should in injunction cases. District courts are the right place for injunctions to be decided, not in the Supreme Court. But he stayed this case, and it's a famous case. There was a man who was taken to court, so far so good, and the judge said he is not to be deported. Okay? He was then deported. He was sent to El Salvador, to a prison so scary that nobody ever gets out of it. He'd never been convicted of anything. And this is central to my talk today. When it was ordered by the court that he be brought back as effectively as possible, there are key words there. I think this is the right word. The Supreme Court engaged in a charade where they listened to the prosecutor who was saying, we really can't get him back. We just paid them, I think, $8 million to keep these bad people, but we can't even ask them to get it back. There was a great furor in that, and I do know from experience, occasionally someone in the court might tell somebody at a cocktail party, you better get him back, because they did bring him back. A mistake was made, it said. who made the mistake. I'd like to know. I'd like the name of the person who made that mistake, or was it a mistake at all? I'd love to see him in a courtroom being examined. Did you know that the court had said don't deport him? So he's back in the country. They brought him back and they charged him with a crime. And the crime is transportation of an undocumented person. I had such a case. It's one of the lightest kinds of criminal cases that you can have in the immigration world because, you know, your brother wants a ride, right? Or something, whatever. I mean, that's who we are. We're families. I digress for a moment to say that this administration has done away with descriptions that indicate that we're a diverse country, basically. They forbid the word from being used. So in this case, what will happen? He'll be tried. We'll see what they have. My guess is, as a former defense lawyer, my guess is they don't have a very good case. Bondi said, "What do you got?" And somebody said, "Well, he transported his grandmother down to Safeway." You know, so we'll see what happens. That's worth watching. There are several others of cases of note where they are allowing, by staying the district court, they're allowing the administration to proceed with what kinds of things. I preface this area by telling you, and I thank Carly, my assistant, who was here for the research, that there were transgender people fighting in the Civil War on the Republic side. There's an estimate of 39 million transgender people in the United States. And what are they doing with them? They're excluding them. And where are they excluding them? From the military. I'm writing another book that traces the history of exclusions. And there's a very long list of people being excluded. One of them is that, for example, that women are not capable of fighting. Oh, that they meet Constance Mankiewicz in Ireland, who took 200 women to the Green and fought the British. And that led in various ways to the freedom Ireland eventually got. There is this exclusion going on that is bringing to the halt a period of about 50 years, starting in 1960. And during that period, we have seen maybe the broadest inclusion of people previously excluded in the history, certainly of our country and maybe beyond. The statutes that were passed, the Civil Rights Act, that you can't discriminate against people, and all of that has come to an end. We are, in my view, you didn't ask me to opine on this, but I've been writing this book. We are presently going back to something that we don't want to go to. I include all of you who came here. I appreciate it. We don't want to exclude everybody. We don't want to fight with everybody. We certainly don't want a president that thinks that every city in the country is a complete wreck. And we don't want a president. They went to court. They argued you can't fire federal employees. The district court said that looks like you should get an injunction, and the Supreme Court put it to one side. With the Department of Education, they terminated education grants in millions and millions of dollars. The district court said you can't do it. And the Supreme Court in the Department of Education case said that you can. And every day I get up thinking the worst has happened, and I'm wrong every day. They've attacked law firms. Just a word about that, because it's not in the Supreme Court. But, and I think the Supreme Court is in no hurry to take this one. This is like somebody says, here, hold the potato. And say, no, I mean, it's too close to home, isn't it? It's all the profession and all that. I'll just say this and let this issue go. I can't imagine the managements of the law firms that entered into a transaction with the President of the United States, providing they would give all kinds of pro bono cases to cases that he would send them. I would love to have been at that meeting. I would love to have been standing and saying, any idea what's going to happen to this firm if we do that? And by the way, it is happening. Yesterday, I think it was 8 partners left one of the firms. So there's hope. Here's a case quite different. It has to do with, can you give taxpayer money to religious schools? This has a long history. There have been those on the conservative side that have sliced very carefully for a while, now not so carefully. The Oklahoma Supreme Court held that you can't do that in that case. There was a statute there, and they said you can't do it. It went to the Supreme Court. It was tied 4-4. Justice Barrett didn't participate, I think for good reason. She had some close relationship with one of the parties or something, and she probably shouldn't have done it. And it's important to note that that's not a precedent. 4-4 is not a precedent in the Supreme Court. I would venture a guess that it is a precedent in Oklahoma. I mean, the Supreme Court decided that one. And so what will happen here, and my first wild guess, they'll take another case, Barrett will join the 5, and they'll provide some financial assistance to public schools. I know that people are split on that. If you have kids, they go to religious schools, you know, you're paying taxes, and then you have to pay the school and all of that. So there's 2 sides to the story. But you've asked a person to lecture you who is a very simple person in a way. When I read the First Amendment, I don't see the issue. And when I write my book and I come through about 500 years of experience in England with Henry VIII, who said, I had to have an announcement. He probably signed a piece of paper, but says, you're all going to be members of my church. And by the way, I'm the head of it. And by the way, if you don't, and you're a priest, we're going to kill you. And we're going to take all your property. Okay, that was not that many years before the founders of our country wrote our Constitution. That's what lives and breathes in that First Amendment. They knew what unlimited power was, even if so many in our country now seem to have forgotten that. Okay. I call that a diatribe. Wouldn't you call that a diatribe?
Yes.
He gets excited, you know, and things get said. We have some civil cases. This is lucky. And the question here is attorney's fees. And the issue is, what they held, the plaintiff drivers here have gained only preliminary injunction relief. Question is whether the drivers complaining will get attorney's fees. The answer from this court, and 7 of them, including Roberts, is no. They won't get attorney's fees, even though they won the injunction. Why? It's not dispositive. Not dispositive. May not be dispositive, but they won. And they should get attorney's fees. And who dissented Jackson Sotomayor, and not surprising. Here's a very interesting case, and it's unanimous. A heterosexual woman applies for a job and is given to a lesbian woman. Okay. She applies for another job and a gay man is given it and she sues. And the Sixth Circuit had a rule that there must be heightened circumstances. So it made it harder for her to sue. They struck that down and made it easier for the heterosexual woman to bring this lawsuit. That's where the conservative wing is, that we've crossed that river quite a while ago, that white people, really my people, really, I'm white, we're the victims. And that's going on, but I come back to my first statement. It was unanimous. Sotomayor, all those people are accepting the precedents that make that possible. Water conservation. The city and county of San Francisco. I think when I tell you about this case, you will never drink water here again. If you live in the suburbs, I'd wait until you get home, okay? So in this case, first of all, the issue is how much regulation can be done. And this has been going on for years. I digress for a minute to tell you that I actually was in a predecessor of this case that shows you how the federal government can be unreasonable. Congress passed $1.3 billion for water clearance in San Francisco. Then the city committed to do the work, and then Congress repealed the $1.3 billion and demanded that the city do it anyway, which would have been, as I recall, something like 1/3 of the budget or something. And we went back to Washington, Judge Mayor Feinstein, and they were adamant. But here, there's a different issue. In this case, they held that the agency must tell the city the details of what they must do. I think that sounds okay. And that was what was held. But that's a big case in the water world. The FDA won a case. It's another win by an agency. Remember, there's been a conservative push to reduce regulation, but we have 2 cases here where the agency won. It's a little harder to reduce regulation once you're looking at the merits. And in this case, this is a nicotine delivery system. And it's electronic. The FDA did scientific research. The Fifth Circuit, probably anticipating a conservative vote on this, wrongly said that the FDA had been arbitrary But the Supreme Court, with 6 justices and some concurrences, which made it unanimous, held that the agency did a good scientific job. So that it's the clash between ideology, we got to reduce regulation, to looking at a case with facts that have been really well done. All right. Here's I can see someone behind the counter in the Blom bank, and someone comes up, kind of a disheveled looking person, looks like he might have a gun, and wants some financial services, and gets the financial services, and then goes out and terrorizes the whole city and shoots people and all that. Well, this is against the bank. But no, they can't go after the bank and they reversed the lower courts because you have to have done something, aiding and abetting, for example, actually participating in the crime. And that's a good case. Trademark infringement, I call this an oops case. And you want to talk to the lawyer who did this. And then you want to talk to the same lawyer who appealed because both efforts were lost. Trademark infringement is an important area of the law. And they did get damages for the main corporation. But as to the affiliates, as defendants, affiliate corporations, they didn't plead them. They didn't put them in the charges. And as a result, they cannot proceed with regard to that. The trademark lawyers, I think, will shudder at that idea, and they will put everybody in their complaints. Here's a NEPA case, as it's called. It was an 88-mile railroad, and it had an environmental impact. Kavanaugh wrote an opinion, and the 3 liberals concurred. There's a lot of that in these cases. And in this case, an environmental impact statement that addressed significant environmental effects. They held they must give NEPA broad deference in their decision-making. This is another case where they're saying that agencies are okay. So this is Whitesig versus Halliburton. He filed a federal age discrimination lawsuit against his former employer, Halliburton Energy Services. He later submitted his claims for arbitration and voluntarily dismissed. This is another case where, why did they take this case and who was the lawyer? Because he arbitrated the whole case and lost. Then he tried to go back to court and litigate the same case. And guess what happened? Alito was unanimous. No, too bad, you lose. Criminal cases. There was a murder of a witness that was arranged for in a transaction. But there was only one witness. In other words, the person who did the shooting. But he said, he made me do it. He asked me to do it. There was no corroboration for that. No other witness said, I was there and this is what happened. And the Attorney General of the state confessed error. This case, I think, really raised a question of law and justice. Not everything fits into iron legal areas. And this is one of those. Well, the person who allegedly said, I wish you would do this, was convicted and it went up. But Sotomayor turned it back. And here's where, you really want to say, come on, Thomas Alito and Bennett. Really, the only testimony is the guy who got convicted of doing it, and he says, he made me do it. And there was more evidence because that witness was asked about whether he'd seen a psychiatrist, and he answered he didn't. And there was more in favor of that because one of the questions was, why didn't the attorney cross-examine him on that? He didn't do that. So that would be under the Sixth Amendment, the right to counsel. Criminal, federal fraud, wire fraud, 1343. Convicted, did not intend to cause economic loss. That's the issue. When you defraud somebody and you make a false statement, do you have to intend to deprive that person of economic loss? No. So it makes it easier to get a conviction under 1343, and that was the decision of the court. In Martin, and all these are on your list here, and if I have time, I'll mention a few of the cases that are still pending and will come down in the next 3 weeks, because some of them are really quite important. The federal tort claim, Mrs. Jones and Mr. Jones are sitting in their home when 8 officers bust the door down, come in, injure Mr. who's trying to defend his family. Wrong house, sorry. What you want is down the street and over in the corner. It's about a block and a half, whatever. Okay, don't they get money? Should they get money? There's a unanimous opinion. Send it back to the 11th Circuit. This is an example of them being swamped. There are more. I've been talking on this really interesting subject for a long time. There are more sending cases back to be decided, which seems like they could do it right here, but they don't. And there's some issues that they raise, and some procedures that are raised, but they send it back for further examination below. Here's a case that comes up a lot, and they send this one back too. A death penalty case, mental limitations. Previous cases have held that the line on mental capacity in accordance with a scientific test is 70. And in this case, there were numbers mostly in the low 70s. The man obviously had limitations, but given the possibility of error, it came over to 69. You would think they could make a rule on that and then everybody would know. They sent it back. A case on statutory interpretation. I think it's fair to say that every justice has a slightly different decision. This is one of the hardest things they have to do is decide, is this statute covered or not covered? What did Congress intend? And the fact is that very often Congress is compromising. I'll give you this, you give me that. You vote for me the next time on the other bill and we'll do the thing. Now it's in the Supreme Court. What did they intend? And so they were trying to deal with that. There were two dissents, Gorsuch and Jackson. Thomas wrote an opinion, and here's part of it. Salvatore Delegati was convicted of violating 924C after he recruited gang members to kill a suspected police informant. Held the knowing or intentional causation of injury or death, whether by act or omission. That's a troubling word for lawyers. An omission can be physical force. So Thomas writes for 7 that the defendant is convicted. There's been an awful lot of talk in the press about the First Amendment. Even some of the justices have commented that somehow the prior First Amendment cases, which usually protected speech, are somehow out of date. It all needs to be redone. There are all these people on social media and they're saying things and they're false and we don't know what to do. Except the First Amendment says that you can talk and you can say things. And there is law. If you defame someone or something like that, you can be sued. The Wisconsin law has an exemption for a religious exemption for certain types of taxes. Stop. That's, to me, and I'm out of date on this, but I love the old days. You can't give an exemption to a religious school because that's in effect contributing support for them while everybody else pays those taxes. That is not mentioned in this case. Sotomayor writes a unanimous opinion and they describes in different ways that the sin, if you want to use that word here, of the Wisconsin Supreme Court was they actually got into the religious issue and they pulled it apart and they looked at it and were deciding whether it did qualify or didn't. But in doing that, they were examining the religion. Supreme Court said, no, can't do that. Sotomayor was for a unanimous court. We have 2 gun cases, and one of them, Gorsuch wrote for 7, and Alito and Thomas dissented. It was the gun kits case. Evidently, you send away like the old Sears Roebuck, and you get a kit, and you assemble the thing, and it doesn't have any numbers on it, which is required by law, and that's important. There's law that tells them what they have to do. They have to keep sales records, conduct background checks, mark their products with serial numbers. Guess who likes these kits? Criminals. And but the court, I thought, did the right thing. 7 of them. And I was supported in that idea by the fact that Thomas and Alito dissented. It always makes me feel better about what I might say. And you can regulate those those kids. The Mexican government, it's an interesting case, sued gun manufacturers for selling guns to the cartels. Says that, wouldn't it be good to stop that? I mean, but Kagan, for a unanimous court, held the government of Mexico sued 7 American gun manufacturers, alleging that companies aided and abetted unlawful gun sales that routed the arms to Mexican drug cartels. But they don't have sufficient support in the record that they were aiding and abetting any of the crimes that the cartel people do. So they lost on that case. And the final case, before we get briefly to some cases that are coming, the Fourth Amendment, violence by the police. A claim that a law enforcement officer used excessive force during a stop of arrest is analyzed under the Fourth Amendment, which requires that the force deployed be objectively reasonable from the perspective to a reasonable officer at the scene. That's the standard. And we have some people here that know about these issues. But in this case, the policeman pulled the car over. It's not clear to me what the problem was. But instead of stopping, he slowed down evidently, or came to a stop. But as the policeman went forward, he started up. The policeman jumps, evidently there was a running board, must have been a very old car, jumped on something and pulled his gun and shot him twice and he died. Okay, my instincts are that there ought to be a case here. But Kagan held that this standard is the one that I read you and not the one that was used by the lower court. And so they sent it back for a determination on the correct standard. I suppose it's too much to ask that they actually decide that you can't shoot people as you stop them with a bad light or something. But anyway, I thought I would mention a couple of these cases to look for. And here's a blockbuster. And I'd be happy to take some questions. Tennessee has a statute. Senate Bill 1, which prohibits all medical treatments intended to allow a minor to identify with or live as a purported identity inconsistent with the minor's sex, or to treat purported discomfort or distress from a discordance between the minor's sex and asserted identity. What do you think they'll do with that? This is a game anybody can play. How many of you think that they will uphold the Tennessee statute?
I think you're gonna send it back, Jim.
That's a good guess.
No, I'm serious.
Yeah, they might indeed send it back, but that's no fun. I think, no, I think it'd be close. I think it'd be close. I think it's a very, yeah, they will send it back. They will send it back. there's a number of important cases. You know, they hold the most controversial cases to the last day. And we'll see what happens on July 1. Whether under the American with Disabilities Act, notice that we have a president who is opposed to people with disabilities. He has said that out loud. In 1960, this is part of my book, the number of employed is not shown with disabilities. It's not shown anywhere in 1960. Most recently, 22% of people with disabilities are employed. That took a lot of work by a lot of great lawyers. I know a few of them here, working uphill, trying to get statutes passed and try to get disabilities to be there. But this is one of the issues I fear we're headed back. And in this case, a former employee who was qualified to perform her job was then trying to get damages. And so it will either help the disabled by allowing damages, or it won't.
The name of that case?
The name of that case is Americans with Disabilities Act. That's what it says here. Whether under the statute is the Americans with Disabilities Act, and the name of the case is Stanley versus City of Stanford. Okay. Oh, this is a case that if you have a house somewhere where you want to store nuclear waste, this you know, you would think I'm drinking and I'm making it up, right? He's old, I'm old, what does he know? No. The question here is whether the Atomic Energy Act of 1954 and the Nuclear Waste Policy Act of 1982 permit the Nuclear Regulatory Commission to license private entities to temporarily store spent nuclear fuel away from the nuclear reactor sites where the spent fuel was generated and next to your house. Okay, how many of you would be a little reluctant to see that happen? Thank you. That's worth waiting for. Do public schools burden parents? This is an interesting case. Mohammed versus Taylor. This is a handout, by the way, so you have the names of these cases. Do public schools burden parents' religious exercise when they compel elementary school children to participate in instruction on gender and sexuality against their parents' religious convictions? The parents' religious convictions, not the juvenile, which is tricky. Juveniles cover a lot of ages. Religious convictions and without notice or opportunity to opt out. That's interesting. Parent control is the issue. That's the issue. Not sure what they will do. Well, I think they will hold that without consent, the child is allowed to perhaps absent themselves, which is, if you picture it, there's Johnny or Mary, they were in the class and they're going to talk about sex. Well, we know they've already talked about sex. All right, we know this. Okay. But they're going to get up and leave. That's not terrific. Louisiana versus Calais. And here is about the fifth case in the last 10 years, trying to deal with whether the legislature used race to structure the districts following the every 10 years restructuring of legislative districts. Did the majority err in finding that race predominated in the legislature's enactment? The court has been all over the place on this. And here they are again. We'll see what they say. Free Speech Coalition versus Paxton, whether the Court of Appeals erred as a matter of law in applying rational basis review to a law burdening adults' access to protected speech instead of strict scrutiny. I'm hoping they will find it's got to be strict scrutiny. Any questions anybody has? Yes.
I have a question about judicial review, Jim. Do you think that the court is going to express its opinion on judicial review? And how do you think that the court will come out if there's some just abrupt challenge to say that the district court judge doesn't have the authority to make a constitutional decision when the president is making it?
They're going, it's my opinion, they're going to give him whatever he wants.
Even on judicial?
Let me take the suspense out of it. They're going to find a way to not hurt him. We're in ideology land. The conservatives are experiencing a once in a lifetime, quote, opportunity to do what they want to do. And they're going to hurt a lot of people when they do it. And so I think they're not going to slap his wrist, obviously, and they're going to find ways to not hurt him. Yes.
Yes, I was wondering, do you think a district federal judge has the right to tell the president of the United States that he can enact something that affects the whole country or not? I'm just asking.
They're going to find that the district judge does not.
Okay, one last question. When it comes to Dodd-Frank, how come more people are sounding the alarm that they already are in great peril if the financial system has a problem, and that laws have already been put in place to take away all their money in the bank and all their money that is in their retirement plans, yet they seem to be unaware that these laws are enacted and ready to be implemented, and it will cause great harm to everybody's asset management.
I think that touches upon a big problem
Once asleep.
that goes across the board, conservative,
I know.
whatever.
It's being, no one's talking about it.
Yeah,
And it's going to affect everybody, and they seem to be closing their eyes with blinders on.
Yeah.
Walking to the.
they're out of touch.
But why aren't?
They're out of touch.
Sounding the alarm, or you fear retaliation for bringing this to light.
Not only are they out of touch, the only thing I'm aware of that members of Congress are looking for is money. And they actually now announce sometimes they don't want to have meetings with people. They don't want to come out here and listen to questions about things and say, tell me about that. They're remote. They're removed. And the budgets they have to raise to try to stay in office are humongous.
It's a Ponzi scheme, your Federal Reserve System.
Yeah. We have lost something very precious, which is, you know, if I was in Congress, and depending on where my district was, and so maybe without it, I'd go out and talk to the farmers if I was a Democrat. I go talk to the farmers. What are your problems? Can I help you in some way? Do you need a statute?
Right to repair.
I don't want to go further. Yes.
So what happens down the road if the Supreme Court hands the president a really bad defeat, and he says, doesn't apply to me, I'm gonna do what I want, or could that even happen? Are you worried about that?
No, I'm not worried about that. I would love that. Because some judge has to throw somebody in jail. Everybody else is subject to that. Every person that walks into a courtroom is subject to the possibility of contempt. If we have a system at all, it has to include the manners and reasonable, but judges are good at putting it off and say, okay, calm down. All right. Let me think about what you said. You come back on Tuesday or something, let's just all calm down. They're good at that. I've seen them do it. They don't want to file contempt charges. But we've already passed the point where some judge should have said, you just said that. That's not true. Marshall, take them in. It'd be a glorious moment. I wait for that. On that note, we'll close. Thank you.